What do you mean programs are talking to each other? They're alive? Yes, they are alive. Kind of, not really. Welcome back to Wine and Chill, your home for all things legal shenanigans. I'm Stephanie, your friendly neighborhood lawyer. Well, if you're new here, not your lawyer, which brings me quickly to our disclaimer. By watching this video, you understand and acknowledge that this video is solely for entertainment purposes only, and you agree that you've read the full disclaimer down below in the description box. Hello, how are you? So for the wine and chill, today we are having Black Girl Magic Riesling. Our continuation of supporting Black-owned brands. If you're new here, you may not know I am a tech attorney, formerly a entertainment law attorney, which tech attorney just means that I work in the tech/startup space. People always ask, what do I do all day? Because I don't go to court. I negotiate software deals all day. So it brought me a lot of joy that Jace reached out and asked if we could do the Google versus Oracle case. So that's what we're gonna do. So as usual, if you're new, the way this works is I'm going to slide over a little bit to the side. I will put the whole lawsuit here to the side of me so you can read along and link it below in the description box. This is going to be the first Supreme Court case that we cover on the channel. So with that being said, a few basics about how Supreme Court cases work. No, you cannot just waltz up into the Supreme Court and say, SCOTUS, can you look at my case? It doesn't really work like that. There are some procedures. So we're going to go over that really quickly so all of it makes sense. So first and foremost, before you even get to SCOTUS, Supreme Court of the United States, I didn't realize that's what SCOTUS meant until I went to law school. I'm going to be very honest. You have to go to trial court, and then you have to go to appellate court, and then finally you can ask the case to be heard before the Supreme Court. So in this case, Google and Oracle, first they went to trial court. The trial court found for Google, Google won. Oracle then appealed. They went to appellate court twice, in which Oracle won, it got sent back down to trial court, etc., etc. This case has been going on for nearly a decade, a long time. And finally, it went to the Supreme Court this year and was ruled on earlier this month. The Supreme Court does get to pick and choose whose case they want to hear. In case you were curious, Supreme Court gets about 7,000 cases asked for review each year. They only see between 100 and 150. So they're pretty selective. Generally, they choose cases that are going to set a precedent throughout the nation. Think Roe v. Wade, Plessy v. Ferguson, things that have an impact on your daily life. The Hobby Lobby case. Why is this case important and what will it do for you? This case is important because Google runs everything. But really though, they do. And this would have extreme ramifications on everyone in the software world and also how you utilize a lot of apps that you're unaware of. A brief bit of background about the case. So Google used the original API in code. We're going to go over what API means in 2 seconds from Sun Microsystems. Sun Microsystems was bought by Oracle. Oracle then sued Google for using their API, saying like, hey, it's copyrightable and we didn't give you a license to use this, so run me my check. To which Google said, no, it's not copyrightable. And also if it was, it's fair use. So that's what we're going to talk about. So that's the 2-second background. You may be wondering, what the heck is an API? An API is Application Programming Interface. Still confused. It's okay. I had a few engineers explain this to me multiple times over the years. If you want to read how the Supreme Court, SCOTUS, broke down API, pages 3 through 8 of the case, do a great job. I'm going to give you a short, truncated version that will hopefully make a lot more sense to you a lot quicker. API basically is the acronym for Application Programming Interface, which is a software intermediary that allows two applications to talk to each other. Still a little bit dense, still a little bit techie, right? Okay, let's break it down this way. So I'm going to link this MuleSoft video in the description box. It's about 3 minutes long. It's a good quick reference that kind of explains what API is. Like, what do you mean programs are talking to each other? They're alive? Yes, they are alive. Kind of, not really, but they do talk to each other. So basically in the MuleSoft video, they describe API as a waiter who goes back and forth between you, the customer who sees the menu, and the kitchen. So all the waiter does is go, takes your order, okay, tells the kitchen, gets your order from the kitchen, brings it back to you. That would be the API. So in keeping with a food example, think of Seamless, Grubhub. So Seamless has their API that when you order, so I go online to Seamless and I say, hey, I'm gonna order some sushi from Seamless. That's generally what I order. So what's like the first thing Seamless does? They take your order. The second thing is they automatically talk to your bank and say, hey, does Stephanie even have this money? So they connect to Bank of America. How the heck are they connecting to Bank of America? Almost instantaneously, it's via the API. So the Seamless API and the Bank of America API, I don't have Bank of America, I'm just doing an example copyrightable. The Bank of America API are then talking to each other, saying like, okay, does Stephanie actually have this money? Because we're not about to make her this sushi unless she has this money. So Bank of America is then going to say, okay, yeah, Stephanie does actually have exactly $15. The order is $12. You can run her that sushi. Then Seamless will tell the actual restaurant through their connected API, okay, restaurant, Stephanie has the money. She's going to pay you. You can go ahead and make her order. The restaurant then will connect via the Seamless API to the driver. These drivers sometimes are outsourced. So via their API and say, okay, Stephanie lives next to the bodega. Okay, good, go deliver her food. The delivery driver actually most likely will pull up Google Maps, Waves, whatever. That will connect. He'll put in to the user interface like, hey, I need to go to Stephanie's house. This is where she lives. And then he'll pop up at my door and deliver my food. As the consumer, all this is seamless to me. Seamless. All of this to me is instantaneous. I don't have to sit there while it's checking my bank account. It's pretty much automatic within milliseconds to tell me like, okay, yeah, Stephanie has that money. I ordered her food, blah, 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 and it's running like that. So that's what the API does. The API is a set of protocols that just allows different applications to talk to each other. That's all API does. Our next techie definition is going to be OSS, open source software. So open source software is a type of computer software in which source code is released under a license in which the copyright holder grants users the right to use, study, change, distribute the software to anyone and for any purpose. So the benefit of open source software and the benefits of open API, it allows people to create more things. So specifically, programmers have been trained traditionally in certain programming languages. Old schools like C++, which people are like, the heck is that? Nobody uses that anymore. New schools like Java, Python. So programmers are trained in these coding languages. It's much easier, instead of building your own coding language, to use a coding language that you know that a bunch of programmers know. Which then brings us to the case and what happened. So in this case, Justice Stephen J. Breyer, he wrote the majority opinion. The opinion is what you read. The opinion is setting the precedent, the case law, the common law, if you may. Now, when I say he wrote it, the law clerks generally write it, which are trained attorneys. It's very prestigious to work for SCOTUS as a law clerk. So they write it, he reviews it, makes his edits, and then that's how you get the opinion. And then there's always going to be also a dissenting opinion. Justice Thomas wrote the dissenting opinion because, you know, it's for big capital business, child. In my opinion, that man is miserable. Anyways, so what are the two questions at play in this case? So one, is API copyrightable? Because only certain things are copyrightable. And then two, is Google's use fair use? So we are going to go through the case. This is a little bit different. Usually we go by paragraph. If this is your first time reading a Supreme Court case, it's by pages. They don't do paragraphs. So I'll just tell y'all what page we're on. Okay, cool. So let's start with page 1. Google LLC petitioner versus Oracle America Inc. And if you don't know who Oracle is the OG tech giant who, you know, child, they have seen better days. Oracle America Inc. is the current owner of a copyright in Java SE, a computer program that uses the popular Java computer programming language. Google, without permission, has copied a portion of that program, a portion that enables a programmer to call up pre-written software that, together with the computer's hardware, would carry out a large number of specific tasks. Lord. Now, why is this so important, this little bit of script? It's because what Google used it in. Now, had Google put this in, you know, some little product that they decided that, you know, that they were going to throw away, then we wouldn't be hearing about this. It's because Google used the JavaScript, the Java coding language, in Android. In Android, unbeknownst and much to the chagrin of the blue dot people, I'm a blue dot person, I use iPhone, actually powers a lot of things in the world. The Android platform is actually one of the most powerful platforms. It is a superior phone. Says me, who's still using Apple. I like the UI on Apple better, but Android is actually a better phone. What do you think? Let me know in the comments. Are you a blue dot or a green dot? I know the green dot really annoys people. I mean, it doesn't really bother me that much. Actually, which is a good segue, if you can hear me better, it is thanks to Babe, who is a green dot, for buying me a mic. Thank you, Babe. Y'all know I have a mic for the longest time. See, we're leveling up. Back to the case. Page 3, shortly after acquiring the Android firm, Google began talks with Sun. So Sun Microsystems is actually the original owner. Oracle bought Sun Microsystems, which after they bought them, they then proceed to sue Google. Talks with Sun about the possibility of licensing the entire Java platform for its new smartphone technology. But Google did not want to insist that all programs written on the Android platform be interoperable. As Android's founder explained, the whole idea about an open source platform is to have very, very few restrictions on what people can do with it. So Google originally asked for permission and then was like, actually, you know what, we don't need y'all. We want it to be open source, because open source means that if for some reason I just magically became an expert programmer, I could just build my own app off of the open source code and then say like, I'm gonna make a wine and chill app. So let's go to the next paragraph. The record indicates that roughly 100 Google engineers worked for more than 3 years to create Google's Android platform software. In doing so, Google tailored the Android platform to smartphone technology, which differs from desktop and laptop computers in important ways. A smartphone, for instance, may run on a more limited battery or take advantage of GPS technology. The Android platform offered programmers the ability to program for that environment. To build the platform, Google wrote millions of lines of new code. That's important. Millions of lines of new code. This argument is about 11,500 lines versus the millions of lines of new code. So that way we have in context what exactly they borrowed from Oracle. To build the platform, because Google wanted millions of programmers familiar with Java to be able to quickly work with its new Android platform, it also copied roughly 11,500 lines of code from the Java SE program. The copied lines of code are part of a tool called an application programming interface, or API. So that's where the API comes from, and that's what this whole argument is about. The measly 11,500, and it sounds like, outside of context, 11,500 of anything sounds like a lot. $11,500, a lot of money. 11,500 railway systems, a lot of railways. 11,500 lines of code, cannot do anything for you, but it's not really gonna do much. Millions of lines of code, however, is a whole program, which is the Android platform. So now we are going to go to page 8. Now we can return to the copy at issue in this case. Google did not copy the task implementing programs or implementing code from the Sun Java API. It wrote its own task implementing programs, such as those that would determine which two integers is the greater or carry out any other desired, normally far more complex task. This implementing code constitutes the vast majority of both the Sun Java API and the API that Google created for Android. Remember, there's two questions. One, is this even copyrightable, which we're gonna get to? And then 2, is this fair use? So we're gonna scroll down to page 13 and 14 and talk about fair use. Fair use, we've talked about this channel in the context of music. Fair use usually comes up with music. What amount of someone else's music can you sample, aka the Nicki Minaj, Tracy Chapman case that we talked about, while with it still constituting fair use, versus what is like, yo, you stole my stuff, like run me my check. I was gonna curse. You can use the fair use context apparently in computer languages, which is interesting. I think it's a very interesting argument, and we'll get to like my thoughts on this at the end. So we're gonna scroll down, we're on page 13. So this is from Stewart v. Abend in 1990. This is, so 30 years ago. Like, these cases are old. They need a little updating, to be honest, because these cases don't necessarily have our high technology life in mind, which is why SCOTUS is trying to like expand things, minimize things. It's interesting. So the fair use of copyrighted work for purposes such as criticism, comments, news reporting, teaching, scholarship, or research is not an infringement of copyright. In determining whether the use made of a work in a particular case is a fair use, the factors to be considered shall include, there's 4 factors: purpose and character of the use, including whether such use is of commercial nature or is for non-profit educational purposes. Nature of the copyrighted work. Okay, what type of work is this? Certain things are not copyrightable. We'll get into that. 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. 11,500 lines of code versus millions. Number 4, the effect of the use upon the potential market for or value of the copyrighted work. Android platform is very large. I don't know whether it's bigger than Apple. Actually, is the Apple platform ecosystem bigger than the Android platform? Y'all let me know in the comments. You know, help me help you. There goes your homework to do a little research too. I had to read the whole lawsuit, okay? And do the background information. First, so on page 14, they're gonna go through all the lines like, okay, how does this apply to this case? So first, the API includes implementing code, which actually instructs the computer on the steps to follow to carry out each task. Google wrote its own programs, implementing programs that would perform each one of the tasks that the API calls up. So for the first prong, which is the purpose and character of the use, they're like, okay, cool, give that one to Google. Second prong, the Sun Java API associates a particular command called a method call with the calling up of each task. The symbol java.lang dot, for example, are part of the command that will call up the program, whether written by Sun or here as by Google, that instructs the computer to carry out a larger number of operations. Oracle does not here argue that the use of these commands by programmers itself violates its copyrights. So that wasn't part of Oracle's argument. So, you snooze, you lose. Like, it's just calling something up. Like, what is it actually doing? Like, what is copyrightable there? So third, what was our third problem? The amount and substantiality of the portion relation. So this is the 11,500 versus the million. So we don't have to read that part. And then, so what's interesting here is prong 4. Prong 4 is market effects. So if the court were to find for Oracle, what would be the downstream effects of that? Now remember, the Android system is used across the world. So it wouldn't just be Google who all of a sudden owes Oracle money. It would be privatizing the Java API, the 11,500 lines of code that are located inside of the Android platform and the Android API now, which is open API that other programmers are using. So the trickle down effects of this would be devastating to the technology ecosystem, to be honest. A lot of the software that you use, if you do have an Android phone, is built off of this because they want more and more people to build different programs. The reason for that is the more you use it, then you're obviously using their software, and then you can kind of control this, which is like Facebook API is the same way. It's semi-open. You gotta sign a lot of T's and C's to use Facebook API. Negotiating with them is a pain in the ass. So now we talked about the fair use and we haven't talked about the copyrightable part. This part is interesting. So we're going to go to conclusion, but because I have to go to conclusion to get to the point of why we haven't talked about is API even copyrightable. In conclusion, which you probably already know if you Googled it, Google. In a 6-2 decision, so 6 justices voting yes and 2 dissenting, the court found that yes, Google's use was a fair use. However, the court decided not to comment on whether an API is copyrightable, much to the chagrin of the majority of my programmer colleagues, who were a little bit irritated, happy that the status quo is being kept, but irritated that SCOTUS didn't take that leap, to protect the industry and just say like, hey, OSS, Open API, is good for everybody. It keeps a great free economy. It allows people to create more. Allowing one huge conglomerate to own something will have very negative downstream effects, as we have seen, at least monopolies. So on page 2, we're going backward, where it's talking about the act. So we're going to go like towards the last sentence. To decide no more than is necessary to resolve this case, the court assumes for argument's sake that the copied lines can be copyrighted and focuses on whether Google's use of those lines was fair use. So in the beginning, they were like, listen, we're not going to talk about this. We're just going to assume this in arguendo, and we're going to go with this prompt. Okay, but why? Page 15, a holding for Google on either question presented would dispense with Oracle's copyright claim. So as long as Google won either question, they win the case. So this is from the opinion, given the rapidly changing technological, economic, and business-related circumstances, we believe we should not answer more than is necessary to resolve the parties' dispute. We shall assume, but purely for argument's sake, that the entire Sun Java API falls within the definition of what can be copyrighted. We shall ask instead whether Google's use of part of that API was fair use. There are certain things that cannot be copyrighted. So first, the Act provides that copyright protection cannot extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, etc. None of those things can be copyrighted. However, it took the court a long time, child, and not just the court, it took the legislature, so the Senate and the House, a long time to really understand like how computer programs work, and they then built out a whole task committee to understand computers and to then allow for laws to copyright computer programs. An API, if we're talking about it, and I told you, API, all it does is allow people, child. They're really not alive. Please, that will give me anxiety. All it does is allow programs to talk to each other so that way they can work. Process, system, method of operation. In my opinion, an API would fall under a process, a system, or a method of operation. It's just a method used to operate 2 separate applications. The application itself, yeah, of course, I should be able, like if, I made Wine and Chill app, and the app just told you, this is the wine of the week, this is how you order it, I don't know, like whatever cool things go in apps. was a social network tied to wine, who knows, whatever. If I made a social network for people that love wine, I should be allowed to copyright that. I don't want someone else to come and take my great app, mimic my app, and sell you something else. I wouldn't want that. However, my app talking to your bank account, just, to make sure you got some money, honey, why should that be copyrightable? I think it's a missed opportunity on SCOTUS's end, but I also understand the hesitation because things change so quickly that you never know, which is why SCOTUS will always generally ease on the side of caution. But I think it's interesting because they've allowed the slight window to be open for some other mega tech company to come in and be like, actually, I am going to copyright all of this stuff. So we'll see. I would say what's going to be interesting, maybe in like the next 10 years, you probably see a different case of someone trying to copyright a certain API that's widely used because it can be super lucrative. If Oracle were to win, Google would have owed them tens of billions of dollars. Billions. On that note, thank you for tuning in. I appreciate you. Let me know in the comments, what do you think about this case? Do you think that SCOTUS should have ruled that APIs are not copyrightable, or do you think this was the right decision? It's a middle ground decision. So, the decision is positive, but it could have been more positive. Also, if you ever have a case that you want me to discuss, let me know in the comments. Since you made it to the end, that means, we're buddies now. You should tune in on Fridays at 7 p.m. Eastern. This will be the third live weekend wind down that I'm doing. It's on Friday, so that way the UK peeps can also tune in. But yeah, you should tune in. It's a lot of fun. We talk about basically like the old Wine and Lawsuits Wednesday setup where we did multiple cases. That's what it is, but live. So you can call in, we can chat, we can talk about different things. I'm thinking of doing a chit chat instead of like just lawsuit baits. Let me know in the comments if you're interested in that. Maybe we can do like hot topics. Y'all could give me some Twitter topics, so y'all know I don't have the Twitter. All right, if you haven't already, please go ahead and like and subscribe. I'll see you in the next video.